Folks, before we left, we took the break, we were talking about discharging taxes in bankruptcy. And there's a few things you got to know before you're considering discharging taxes in bankruptcy. Number one, you must be an individual. And I mean that as an individual as compared to a corporation. If you have a corporation and you want to file bankruptcy for the corporation, thinking you're going to get rid of those taxes that, the trust fund tax we talked about, or some other type of tax, that's not going to work. Corporations cannot discharge taxes in bankruptcy in a Chapter 7 or a Chapter 13. It just doesn't happen. And I'm not going into Chapter 11s because we're talking about a much more complicated process there. Number two, it can only be an income tax. You can't discharge other taxes like excise taxes or trust fund taxes or something else that's a non-dischargeable debt. So that's very important to know, and especially the penalty in the trust fund. I don't want to go there. Folks, if you have a business and you're withholding taxes from people's paychecks, pay them to the government. One of the worst things I see is that people don't do that. I'm told we got about 3 minutes left in the show, so I'm kind of going to hit these things. We talked already about no willful or fraudulent evasion of taxes. If you're a tax protester, my advice, don't get anywhere near the bankruptcy courts because you're not going to get assistance. Number 4, the 3-year rule. It would be a 3-year rule kind of kicks in. The taxes have to be older than 3 years. In other words, if you have taxes that you filed timely within the last 3 years, those debts are going to be presumed to be non-dischargeable. And again, that 3 years has to kick in prior to the bankruptcy petition. So if I know somebody who's got a 2007 IRS debt, it was for taxable year 2007, but they didn't file the bankruptcy, they're thinking about filing the bankruptcy in 2011, I know I'm good because 2008, 2009, and 2010 have already expired. So then I got to look at, well, what is the 2-year rule? The 2-year rule is you must have filed the tax return more than 2 years prior to the bankruptcy petition. So you got a tax debt that's 3 years old, but you have to have 2 years between the date of the bankruptcy petition and the tax return. Then you got what's called the 240-day rule, and that's the assessment date of the taxes. In other words, when you file the tax return, when did the IRS assess the tax? And that's got to be more than 240 days before the date of the bankruptcy petition. I know this is kind of exhausting. Then you got a tolling rule of the 2 and 3 years. And what happens? How does a tax debt get tolled? I'm looking at my notes here. The tax debt could get tolled by a prior bankruptcy filing. So let's say, for example, the IRS is coming after you. You file a bankruptcy. That bankruptcy lasts, it's a Chapter 13, it lasts 6 months, and then you go ahead and you dismiss the case. What happens then is that statute of those time periods that we talked about, the 3-year, 2-year, and the 240-day rule, are tolled, meaning they're stopped temporarily, kind of held in abeyance, and then extended beyond there.